Hello everybody, let's get this party started. Let's talk again about the case of State of Florida versus Donna Adelson. And in this video, I'm going to be talking about two motions filed by the defense. I think it was great for Donna. It was a smart choice by Donna to hire a good lawyer, Alex Morris, who also has a lot of experience with appellate work. A good appellate lawyer, and I've done more than 100 appeals as well myself. A good appellate lawyer is really good at spotting issues and arguments that can be made, that should be made in a case. And so I can tell you that there are several motions that have been filed by the defense, and all of them, or most of them, seem to have good grounds, right? So these are arguments that probably should be made. Now, whether they're going to prevail or not, that's sort of what we're going to talk about. I'm going to give you my opinion on that issue. But they at least identified issues to be raised with the court and issues that, at least merit some discussion. We're going to talk today about two of the motions that were filed because they're both related in a sense. So the one motion that I was planning to do exclusively on this video is called Defendant Donna Adelson's motion to dismiss indictment for pre-indictment delay or alternatively to exclude evidence. Now, I'm only going to talk about the motion to dismiss part, because I haven't even read the second half of this motion that talks about excluding the evidence. And then I'm also going to talk about a related motion, and I'll explain to you why it is related. But it is Defendant Donna Adelson's motion to preclude evidence of Donna Adelson's travel as consciousness of guilt. So those are the two motions I'm going to talk about. And let's just, in general, first of all, talk about the principles at issue right here. All right. So on the first issue, the first motion, the motion to dismiss the indictment for pre-indictment delay, there is case law that talks about that being a possibility, right? That a case may be dismissed because of some misconduct by the state that caused prejudice to the defense. And what is the general rule? Yeah, I'm going to read it to you guys from a case called United States versus Stokes out of the First Circuit Court of Appeals of the United States Court of Appeals. And this is a 1997 opinion, and it talks about the issue of pre-indictment delay. And here's one paragraph that kind of sums it up what is required for you to be able to rely on that kind of argument. So it says, Stokes' renewed claim of unconstitutional pre-indictment delay lacks substance. A criminal defendant who asserts such a claim bears a heavy burden of showing not only the pre-indictment delay caused him actual substantial prejudice, but also that the prosecution orchestrated the delay to gain a tactical advantage over him. So what are they talking about here? For example, right, let's say that the state of Florida believed that Donna Adelson was involved in this murder, and that they were going to argue that she dropped off the money at Charles Adelson's home. Let's say that they knew this right away, and that they, on purpose, orchestrated the delay, did not charge her for 10 years or 9 years, whatever long it took here, not because they were trying to develop evidence and they didn't feel like they have enough or some other good reason, but because they wanted to preclude her from obtaining exculpatory evidence. They figured, oh, shoot, we can argue that she dropped off the money, but if we wait a few years, she'll never be able to get those records, and now it's going to be an easy conviction. So let's delay. Let's not file now. Let's delay so that later on, when we finally get a charge her, she's not going to be able to defend herself. If something like that were to happen, and you can prove that, and then you can show that there was actual prejudice, that now, yeah, you can argue those toll records and whatever, then you may have an argument, right? But even without reading the motion, let's just backtrack for a second. I mean, because the initial gut reaction that I have when I read this is like, I mean, do you have the audacity to really argue this? Let's consider all of the facts that we know, right? Based on Charles Adelson's own testimony, the Adelsons knew that they had a connection to this murder, even if they were not involved. They knew that they had a direct connection to this murder through some people that supposedly did it for them and then wanted to collect money from them. They knew this from that night while Dan Markel was still alive. Charlie knew that night, supposedly. And then a few days later, a few weeks later maybe, his mom learned about it when she was asked to write several checks for Catherine McBanua. And then she confronts her son, why are you asking me to write all these checks? And he tells her the truth. So back in 2014, the Adelsons already knew this, that they could be implicated in this murder. Now, of course, the defense doesn't have any burden to do anything once they're charged. But here, let's just take a look at the hypocrisy of this motion, right? The defendant in this case, Donna Adelson, knew that there was all this evidence that would point towards her family's involvement and her involvement in the case. They could have gone to law enforcement. They could have gone to a lawyer and tried to develop any and all possible exculpatory evidence back then, knowing that someday the state might find some evidence to charge them, because you know what? Those people that are extorting us may someday decide to turn us in. If they get caught for something else, whatever, they're going to try to make a deal and say that they have evidence about who murdered Dan Markel and that it was all ordered by the Adelsons and blah, 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 right? So they had a humongous interest in developing that evidence, that supposedly exculpatory evidence themselves, way back when. And then the prosecutors, by the way, the other side is arguing when this happens, right, that the evidence of the probable cause affidavit is leaked. And so what do the Adelsons say? That this is, and the attorneys for Catherine McBanua and so on and so forth, this is horrible, this was leaked to the media, they're just going to the media, they're trying to crucify these people and all this stuff, and their own prosecutor says that there's not enough evidence. The Adelsons hire attorneys. They announce that they have nothing to do with this murder. They don't say that they were extorted. They don't say that they know who the killers were. Nothing. They say that we're 100% innocent. We have nothing to do with this. We're glad that the people that killed the Markels were caught, or the Markel were caught, but we have nothing to do with this. And they're lawyered up, right? And so, again, even if they were not smart enough to hire lawyers and develop evidence back in 2014, to help prosecutors prove the case against the real killers and extorters, right? In 2016, they could have done that. So there's all this hypocrisy already from that perspective, right? From the fact that the state wasn't trying to hide anything. They already did a probable cause affidavit, giving warning to, like they said, giving warning to Donna, hey, you are a target of this, right? And if we see the motion, the argument, for example, concentrates on the fact that the defense is not going to be able to prove, for example, the whole issue about the money drop and the fact that the toll booths or the SunPass records would show that she wasn't at her son's house that night to drop off money, wet money, to Charles Adelson. And so that's the, like, I guess the main issue that they argue why they're prejudiced, right? Because they cannot disprove this suggestion that she was there. But when did the state know about that, right? So the state knew about that much, 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 much later, right? They only heard for the first time somewhat during the proffers of Catherine McBanua. Maybe you can half interpret her to say that, because eventually, I mean, that was very painful to listen proffer. The first one and the second one were both difficult to listen. Catherine McBanua was all over the place. She never was clearly stating anything. And so maybe at some moment she suggested that the mom stopped by the house, and then eventually that was actually used at the trial, right, against Charles Adelson. But that's when they learned about it. This is long after Charlie was arrested. This was after Catherine McBanua was convicted. So by that time, when they learned about the supposed money drop, the records probably wouldn't have been available, right? So it's not like they orchestrated anything. They were, in fact, charging the people that they thought had a direct connection and would bring them the Adelsons in a platter right away. They were not trying to delay. They were trying to do it right away. They were cautious. That's a different story. They were cautious, especially because of the fact that the Adelsons were all lawyered up. They were claiming full innocence and all this stuff. And obviously, this is a difficult case. There was well-planned murder with an in-between person who would shield the killers from the people ordering the hit. And it was hard to prove. And the bump was successful in a sense. But again, it wasn't clear cut, right? I mean, Donna does say it's about the two of us, but then again, about the two of us could be about the fact that she's helping after the fact, paying for the extorters or paying for the murder without having been involved before. So it was never a super obvious, clear case where they should have immediately charged. It was something where many people thought, like myself, maybe, I don't know, maybe I was the only one, I don't know, but I mean, I have been speaking about the fact that probably the Adelsons should have been charged long ago. And before any Adelson was charged, I suggested that they should be charged and that at the minimum, it should be at least one of them. And the state actually did that. But this is not a situation where the state was orchestrating a delay to gain an advantage, right? It's not a situation where they had full cooperation of Catherine McManua way back when, back in 2016-17, knew about this suggestion that Donna Adelson stopped by the house to drop off the money, but held on to that information for another 9 years so that Donna Adelson could disprove it, right? So, okay, there may be some actual prejudice from the fact that there was a delay. And that part they may be able to establish. Don't know. But they're never going to be able to establish that the prosecution orchestrated this delay to gain a tactical advantage over Donna Adelson. That would be a pretty absurd argument, in my opinion. So that will never fly. Going to read a little bit this motion and actually give a little more detailed discussion, but I'm just giving you my preliminary thoughts about the two motions. So that's my general thoughts about the motion to dismiss for pre-indictment delay. Again, I personally think that the defense is kind of stuck with the story about the extortion and all that, and they should have done although they don't have a burden to defend themselves, and the state has the burden of proving guilt. They should, if they were victims of extortion and they knew that they were potentially going to be mistakenly charged for a murder that they really didn't want to happen, they should have, if they decided not to cooperate with the cops and get the cops to then investigate and do all their searches and corroborate their own story, which they would have done if they gave a story and said what they did and didn't do. If they had cooperated from the beginning, the state would have gone there. Maybe they would have asked for those records that they're complaining about that nobody got. So those are my initial thoughts before I discuss with you the actual motion. Now, the other motion is the Donna Adelson's motion to preclude evidence of Donna Adelson's travel as consciousness of guilt. And so let's talk about in general. What is that about? Okay. When people flee from the police, it can sometimes mean that they have guilty conscience about something that they have just done, right? They make a good argument, and an argument that they should make. They have to try to do technical challenges to all the good evidence that comes in the case. And by the way, one of the reasons why I thought that the two motions were tied together is because one of the arguments in the motion to dismiss is that the state of Florida has had the same evidence for the last 10 years. And that is incorrect. There are two. From what I know, from what we all know, there are at least two huge pieces of evidence that are brand new. That would be Catherine McManua's testimony and proffer. They didn't have that back in 2016, 2017, 2018, 2019, so on and so forth. Some argue that it is because there is a connection between the Adelsons and the lawyers representing Catherine McManua. I mean, I think that this motion could open that Pandora box again, but who knows? But bottom line is that there is all that evidence about Catherine McManua that came in much later. And then on top of that, there's also this evidence that we're going to talk about right now, the whole evidence of Donna Adelson trying to escape the country, allegedly, right? That's the argument from the prosecution would be that she's trying to flee and that proves consciousness of guilt for the murder. The defense is arguing, hey, wait a second. They discussed this trip with friends. This was one of many, many, many trips to countries abroad. Many of those countries have no extradition treaties. Donna Adelson knew for a long time that she was a suspect and never flew the country. There's nothing to show that this departure to go to Vietnam is evidence of any kind of guilt on her consciousness, that she killed Dan Markel, that she participated in the murder, and it would be highly prejudicial to introduce this evidence to try to imply that this is why she went to Vietnam, when we're like so far removed from when the murder happened and her supposed involvement in the murder, blah, blah, blah. But again, this is like a one-sided presentation. I understand the defense is doing the defense work. I mean, they're not going to make the argument for the state, but I personally think that you always do that. You actually, when you do a motion, you evaluate both sides and you evaluate the evidence fairly. You actually gain credibility with the judge if you say, here are all of the facts, and then, well, even considering all of the facts, you still shouldn't allow this evidence to come in. But they don't do that. They misstate the facts and completely fail to analyze all of the evidence that the state obtained by getting her calendar. That calendar is a huge piece of evidence, and that calendar demonstrates many things, including the fact that she was hiding the trip from people, that she was using her attorney to communicate with Charles Adelson private, so they wouldn't be heard on by law enforcement who were monitoring the phone calls, the fact that she was telling friends, according to her own entries on her cell phone that they confiscated, suggesting that they were going on a vacation, the suggestion that they had a family emergency. They have a note in the calendar to tell somebody about where they are after they're gone. So there's all this evidence that there's the searches on the phone or on the computer to find out whether Vietnam is still a non-extradition treaty country. All of these things. There's the interview of Georgia Cappleman immediately after the trial. We know that they have been watching all of that, so they have the interview where Georgia Cappleman is the first question asked. It wasn't by me, it was by somebody else. Who's next, right? So you have all those things that connect the travel to Vietnam and the whole emergency of how they decided in just a few days after the conviction happened and the departure, right? Just a few days from November 6 to November 13. That's like a super rush, 7 days in 1 week. They go from being in Miami to trying to leave to the country to go to Vietnam. So the analysis here is missing all those facts. And so those are my general thoughts. So my general thought is that this is enough evidence of consciousness of guilt because of the factors that I just told you. So they can try to argue to the jury, hey, listen, she had other reasons, maybe she was afraid of getting it for trial, whatever. They can argue whatever they want to try to argue, but I think that it is enough evidence of consciousness of guilt that it should come in. We'll see how Judge Everett rules on it, but now I'm just going to go do a little more in-depth analysis of the two motions. All right, here's Donna Adelson's motion to dismiss indictment for pre-indictment delay or alternative to exclude evidence. So the preliminary statement says, the case presents an egregious example of pre-indictment delay. The state began its investigation with Mrs. Adelson among its prime subjects just hours after Professor Markel's murder in July 2014. By 2016, the state had focused its efforts through witness interviews, document subpoenas, to charge her alongside her alleged co-conspirators. In fact, the state's evidence against Mrs. Adelson has remained largely unchanged since then. And that's one part that I disagree with. So they say that since 2016, the evidence is largely unchanged. I think that there's two big significant pieces of evidence that came in against Donna. I think that Catherine McBanua would be one. The other one would be all the stuff that was collected after her arrest. So there you go. Oh, actually, no, there's three. Let's not discount the whole admission by Charles Adelson that that they paid for the hit, right? That he paid for it with cash, supposedly from his safe. Maybe he was trying to protect his mom and not revealing that she brought it over. That's a possibility, right? So now they want his admission to somehow be a fact, But that was a convenient admission, I think, a part of their strategy, and maybe one that also involved saving Dan Roshbaum's other client, which clearly Donna was acting like a co-client of Dan Roshbaum throughout the prosecution of Charles Adelson. So I disagree that it remains largely unchanged since then. I think that the trial did present evidence against Donna because after never disclosing for many years this supposed crime that happened against them, they did admit at the trial of Charles Adelson that the payments were made by them. Charlie admitted that he gave money to Catherine McManua, and then he also admitted that his mom wrote those checks and that he told her about the whole extortion. So it kind of, she's a lot more embroiled in the murder than just from us interpreting the wire calls. Now you have the sworn testimony of her son that didn't work, but their hope was that they were going to, his hope was that the jury would find him not guilty because he was a victim too, but that didn't fly. But I think that the state can say that that's additional evidence, that it's not just Catherine McManua, it's not just the stuff that they found after they arrested her, it's not all the stuff that they got on the jail calls too. By the way, the jail calls are evidence too, that conversation that happened after she thought that she was going to hang up, that she had hung up the phone, and she's talking about fleeing to Vietnam and all that. So, no, there's a lot more evidence against Donna than whatever they had in 2016. And we may not know all they had in 2016, but there is a lot more since then. So that's an unfair statement. And so I'm going to go back to reading. Yet the state made the intentional strategic decision not to charge Mrs. Adelson for almost 80 years, choosing instead to pursue charges against 4 of her purported co-conspirators first. I don't think that there's anything wrong with that, right? With going up, first charging the people against whom you have the most and best evidence, and then hoping that they will flip and give you more evidence against the others. A lot of people criticize it as being wimpy, as being too scared, as saying, a lot of people, maybe including me, said that there was enough evidence already from what they had in 2016 after the bump to charge Donna and Charlie. But I understand the state's strategy of being more conservative. So being conservative and trying to develop more evidence against the defendant where the case is maybe a little bit weaker, that doesn't sound like a strategic decision that was intended to deprive Donna Adelson of a fair trial. So when the state finally decided, I'm going to go back to reading. So when the state finally decided to seek an indictment against Mrs. Adelson, more than 9 years had passed since the murder. By that point, exculpatory documents critical to her defense that the state never saw fit to obtain, including cell phone records that to refute the state's call pattern claims and SunPass records to refute the state's unsubstantiated and inaccurate suggestion of a money drop, were lost to foreseeable document retention policies, causing substantial prejudice to her defense. Accordingly, the indictment should be dismissed as a violation of Mrs. Adelson's due process rights. But if the court is unwilling to do so, at a minimum, it should preclude the state from introducing evidence that Mrs. Adelson can no longer defend against because of the state's charging delay. Again, the rule of law on this issue is not just that there was a delay and now the case should be dismissed, because it's kind of like rewarding the better criminals, right? So if you make it harder for the state to charge you, and now you can, because the state took too long, you're going to say, now I'm prejudiced because I cannot defend myself. That would seem to be absurd. That rule exists to protect defendants from misconduct by the prosecutors that are hiding the fact that they're going to charge somebody, okay? Lulling the defense into non-action that once they later decide to finally bring the charges, once they reveal the fact that they're going to go after you, now you can't defend yourself anymore. It's not just about delay. It's about a strategy from the state. And that's going to be something that is pretty much impossible to prove in this case. Because, like I said, from the very beginning, the state was quite forthcoming in asserting its position that the Adelsons were involved. They didn't have the details. They didn't have Catherine McManua mentioning the potential of a money drop. But they certainly let everybody know that their targets are the Adelsons. Not all of them, of course. Robert had nothing to do with this, but they put on their charts from day one, from trial one. Okay, on the one side, like the killers, and then you have the four Adelsons, right? Wendy, Donna, Harvey, and Charlie. They're always part of the state's theory. Uh, so that seems to me like an argument that's not going to hold any water. Then they give the background. They're saying that obviously the Donna Adelson was a target from early on, that they also subpoenaed and combed through Mrs. Adelson's personal and business records going back to January 2013. I wonder if they got her calendars for 2013, 2014. That would have been nice. And of course, in 2016, they should go back and look at those records. I don't know, maybe they don't know they have a gem hidden somewhere that nobody reviewed. And of course, in 2016, they conducted the bump and the wiretap recordings and all that. So it says, so by May 2016, the state had in hand virtually all of the evidence that it is likely to present when Mrs. Adelson's trial convenes next month, almost a decade later. Again, I disagree. There's a lot more evidence now. But the state did not charge her in 2016. Instead, it made the strategic decision to pursue charges against others, against the shooters and Miss McBenoit first, hoping that they would plead guilty and reveal that what the state believes was Mrs. Adelson's involvement. But that did not happen. And so Mrs. Adelson remained uncharged through two trials, and one in 2019 and another in 2022. The state also failed to charge Mrs. Adelson when it charged Charles Adelson in 2022. Once again, the state chose the delay. It wasn't until after Charles' conviction, with no new evidence to bolster its case, that the state brought charges against Mrs. Adelson on November 15, 2023, 9.5 years after Professor Markel's death. I think the whole point about the fact that she wasn't charged with Charlie at the same time seems to be irrelevant to me in this argument, because I think that what they're going to try to say is that the delay and the document retention policies would probably be like 5 years, not 8 versus 9 years or 7 versus 9 years. So it doesn't really make a difference. I think that they probably would have made the same argument if she was charged when Charlie was charged. Let's see their discussion. So the state's 9-year delay in charging Mrs. Adelson warrants dismissal under the Due Process Clause. Even indictments brought within the limitations period are subject to dismissal where the delay departs from fundamental notions of fair play. Citing United States versus Foxman. When the pre-indictment delay, 1, causes substantial prejudice to a defendant's right of fair trial, and 2, was the product of bad faith on the part of the state, dismissal is required. And it cites to the Jackson v. State case. Now, even the Jackson v. State case was one where that argument was rejected by the court. So I'm going to read from the opinion. 5, motion to dismiss charges. So the Florida Supreme Court is writing about this issue. Okay, so this is a case where the defendant was convicted out of Duval County of first-degree murder and was sentenced to death. The name of the defendant is Kim Jackson. Jackson argues that the circuit court, the trial level judge, erred in denying his claim that the trial counsel was deficient for failing to file a motion to dismiss the charges on the basis of prosecutorial delay. In denying this claim, the circuit court ruled that a motion to dismiss for pretrial delay would have been meritless. We agree that Jackson is not entitled to relief. In so deciding, we reconsider our case law on the due process standard for pre-indictment delay. In Rogers v. State, we adopted without significant discussion a balancing test to determine if pre-indictment delay violated due process. That test traced back to a Fifth Circuit decision in United States v. Townley back in 1982. We described the Townley test as follows. So this is the test that they are backing out of and changing. So the Florida Supreme Court, before this opinion, the Jackson case, were following this standard. I'm going to read it to you. When a defendant asserts a due process violation based on pre-indictment delay, he bears the initial burden of showing actual prejudice. If the defendant meets this initial burden, the court then must balance the demonstrable reasons for delay against the gravity of the particular prejudice on a case-by-case basis. The outcome turns on whether the delay violates the fundamental conception of justice, decency, and fair play embodied in the Bill of Rights and the 14th Amendment. So that was the former test. Then it says, since we decided Rogers, the Fifth Circuit has receded from Townley balancing test. In doing so, the Fifth Circuit cogently explained the flaws in the Townley balancing test reasoning. So now here's the Fifth Circuit Court of Appeals, federal court, explaining why they no longer do this balancing test. Here's what they say. The Townley test purports to weigh or balance the extent or degree of the actual prejudice against the extent to which the government's good faith reasons for the delay deviate from what the court believes to be appropriate. However, what this test seeks to do is to compare the incomparable. The items to be placed on either side of the balance, imprecise in themselves, are wholly different from each other and have no possible common denominator that would allow determination of which weighs the most. Not only is there no scale or conversion table to tell us whether 80% of minimally adequate prosecutorial and investigative staffing is outweighed by a low medium amount of actual prejudice, there are no recognized general standards or principles to aid us in making that determination, and virtually no body of precedent or historic practice to look for guidance. Inevitably, then, a length of chancellor's foot sort of resolution will ensue, and judges will necessarily define the process in each such weighing by their own personal and private notions of fairness, contrary to the admonition of the United States Supreme Court in the United States versus Lavasco. Apart from the above difficulty grounding, so now it's the Florida Supreme Court talking again. Contrary to these principles, the Townley test would find a due process violation where the government acted in good faith and did not deliberately seek to prejudice the party ultimately accused. Finally, the serious separation of powers concerns are implicated. Here, for example, the panel concluded that the reasons for the delay, such as lack of manpower and low priority which this investigation was assigned, were insufficient to outweigh the actual prejudice to couch and fry. Finding these reasons insufficient is in substance determining that greater manpower should generally have been allocated to investigation and prosecution and that jurisdiction, and that a higher priority should have been assigned to this particular investigation. So those are decisions by a different body, not by the courts. And so they're backing off of this test. The Florida Supreme Court says, so based on the analysis above, which I only read to you part of it, we recede from Rogers' balancing test, that one that adopted the Fifth Circuit's balancing test. We now align ourselves with the majority of federal courts and hold that a due process claim for pre-indictment delay requires a showing of substantial prejudice to the defendant and bad faith on the part of the state. And like I said, I read to you guys United States versus Stokes, which is the first case they cite. And in the United States versus Stokes case, they explain it even better. They say that the defendant has a heavy burden of showing not only the pre-indictment delay caused him actual substantial prejudice, but also that the prosecution orchestrated the delay to gain a tactical advantage over him. So bad faith. What I do like about this motion, however, is that it puts the government on the spot a little bit, and that hopefully then we'll get to hear an explanation from the state about its decision to not charge Donna Adelson, maybe Harvey Adelson and Wendy as well, for so long. So in a sense, I kind of like that this motion was filed, and I'm looking forward to reviewing the response from the state, but I just don't see the defense being able to show the bad faith component of the test. They may be able to show some prejudice, although I already explained to you why that seems to be a little bit hypocritical, because they knew about their supposed involvement from a long time ago. So even assuming that Donna, for example, was not involved and that she helped her son pay extorters, that's what she believed. She knew about her, that she could be wrongfully, in a sense, charged for this murder way back when. They lawyered up. They never cooperated. I mean, it's really hypocritical in many respects. But it is what it is. So they talk about the prejudice, right? So the actual prejudice would be the whole issue about the transponders, the sun pass, maybe phone records from before to show that they were always on the phone with each other, that it wasn't just around the time of the murder. Because obviously, I think that Katie's defense tried to do the same. Even Rashbaum tried to do the same at Charlie's trial. Talk about the fact that, well, yeah, they show all these phone calls happening around the time of the murder, but these were all people that knew each other: boyfriend, girlfriend, mother, son, brother, sister. They always were talking to each other. So you make it look like this was something proving that they were involved in the hit. Yet, if you go back several months, the whole past year, you're going to find many days where it had no connection to any murder, where they're talking the night before, the next morning, this stuff. So that's sort of the argument that has to do with the phone calls and all. And of course, this whole issue about getting the SunPass records, the transponders, to try to show that Donna wasn't dropping any money and all that stuff. So I don't think this motion is going to fly, primarily because there's no way that they're going to prove any bad faith. But I am looking forward to reading the response from the state so that we can hear an explanation for the delay, which I'm assuming is going to be very similar to what I just said, is the fact that they felt that they had a good amount of evidence, but not enough to quell any concerns. Maybe there was dispute between them about whether there was enough. Maybe some thought that it was, others thought that it wasn't, and the boss is the boss. The boss decided it wasn't enough. But they didn't hide anything from the Adelsons. The Adelsons knew from very early on that they were targets. So anyway, and then the other explanation is, of course, we didn't know about the supposed money drop until we talked to Mike Manua, and by then it was too late to get additional records. We did a very thorough investigation. In fact, Dan Roshbaum had said, and so did, I think, Charlie, I guess, or I don't know who else, but they admitted that the investigation was amazing and that they did a terrific job in finding the killers. All right, let's stop. That's it. Enough emotions. Goodbye. There will be a hearing and a judge deciding them. So, all right, guys. What is seating capacity between the both courtrooms, James? Good question. Okay, I did a video about it last night, and then I made it private for a second because I kind of messed up. I showed 3B first, which is the last place I had a jury trial. It's a very small courtroom. I did a trial there. My last felony trial was there, courtroom 3B. It's very small. You can see the video that I did last night. It actually shows it. It doesn't show the gallery, but the gallery has basically maybe three wooden benches on one side, three wooden benches on the other. It maybe fits 30 people, maybe 35. And given the number of people who were attending last time who were from the media, I would say at least 20 last time. So it basically would mean that between the media and the family of Dan Markel, there would be almost no space for anybody else. Very few people from the regular audience, I guess, would be able to sit there. Good question. Didn't Donna's note say something about investing in real estate in Vietnam or something? Yes, it did. Her calendar throughout the year talks about the fact that they were buying some Vietnam villa. They were investing in it. They had it furnished. They spent about $135,000 on it. Which defense motions do you think will be granted, if any? I'm concerned about the move to 3B, because maybe the judge has the power to do it. He can do it if he wants to. I don't want it to happen. I think it's going to be bad to do that, but he was the judge presiding over Charles Adelson's trial. He got to see whatever was happening in the gallery. He did a couple of times not like, I guess, what's going on. I think it was clear from his face, from his reaction or comments in the breaks. So that's something that he might have an interest in doing. So that's a possibility. Which of the items do you think the defense will be successful in excluding? I didn't go into that part of the motion about excluding stuff, so I can't talk about that yet. I'll have to read it before I give any opinions. Why do you think state is transporting Charlie for trial? Well, that's very simple. They're transporting him here because he's a potential witness. So anybody who's a potential witness and is in prison should be transported here, meaning that there's always a potential that he might decide to cooperate. So if he decides to cooperate, he's here, and hence not in another state, and would not cause any delay of the trial or pausing the trial because now suddenly Charles Adelson wants to testify. It's not because they want to have a mother-son get together, but because of that, because there's always the potential that he will become a witness for the state. And it could be so that the defense requested that Charles be moved here because he may testify in favor of his mom. Who knows? And the state might have done that as a favor. Okay, sure, we'll bring him down. But I think that they would always do that with anybody who might become a state witness and testify. How would you get Catherine to cover up some truths? She knows it all. All right, that's the $1 million question. I know how I would do it if I were in charge. I would get Sigfredo Garcia and Catherine McManua in the same room. Sigfredo to give her the green light to tell the truth. If I could convince Sigfredo to, even if he doesn't want to cooperate, but to give his ex, the mother of his children, of their children, the green light to just go ahead and tell the truth without having any concerns for him, then she might give the full spill. Because we all feel, I think, that she was still not 100% forthcoming. Will Sigfredo ever be called to testify against Donna? Sigfredo will only be called to testify by the prosecution if he's willing to cooperate. And so far, he has shown that he has zero willingness to become a state witness. So that seems very unlikely. Furthermore, Sigfredo Garcia would not likely be able to give any evidence directly against Donna because everything that he knew was coming from Catherine McManua. He had no direct contact with anyone, so it would be unlikely that he would be called unless it would be to corroborate some of what Catherine McManua will say. Thanks, guys. Have a good one. Until next time, Mentor Lawyer, have a wonderful weekend.